2013-218, 2013-221, and 2013-268. State of Arkansas versus Kyle Moats.
Yeah, these are set, all three of these cases are set for reappearance today. I think the only issue at this point, Your Honor, would be to readdress the issue of bond.
That's been addressed.
We have the I'm just quickly making sure we're all on the same page in terms of the status of these cases. The first two of these cases, 2013-221 and 218, are set for trial in March with a pretrial February 6th. And this reappearance date was to check on the status of the case as they proceed. The third case is set in May, that is 2013-268, set in May with a pretrial in March and a reappearance ordered for February 6th, which is the same date as the pretrial in these first two cases. So that's the status of these cases. Are we progressing towards trial?
Yes, sir. I think this will go to trial. This state's taken the review of this case and made a very serious offer that I think this is a case in which the defendant could, if the jury wanted to, give him life in prison. And these are set for trial. He's had a bond revocation. Bonds are reset at $50,000 for our just bond once. I think it's $50,000 in all three cases.
That's what the court has recorded.
Your Honor, I don't know if the court would consider revisiting the issue of bond. Mr. Moats has been in jail 38 days. I realize that I think the court at our last bond hearing stated that Judge Putman had reviewed the bond and had set the bond, had lowered the bond to $50,000, and the court kept the bond at $50,000. Your Honor, I would ask again that the bond be reduced to $25,000. He can live, as I had told the court the last time, with his mother and father, who live here in the Mountain Home area. Actually, Judge, would be his grandparents. He just corrected me.
Judge, this defendant continues to commit crimes. The crime is extreme violence while out on bond. He's out on bond, a $10,000 bond, and he committed aggravated residential burglary. Actually broke in, bound a man, held a gun to his head, participated in all of that, stuck a sock in his mouth, threatened to kill him, did do some physical injury to him. But this kind of conduct concerns the state. This man shows no regard for the safety of others. Thinks he's a bully, thinks he can do what he wants to other people, and we just think the bond is more than reasonable. And any bond he makes, certainly he should be restrained from possessing a weapon, going around any of the witnesses or defendants in this cause or any of these causes. Bond certainly should not be lowered.
Your Honor, as far as going around alleged victims or any co-defendants, certainly we would expect the court to order that. Mr. Kincaid sets out, as the court is aware, merely the allegations that the state has against Mr. Moats, not what the state has proven, what he anticipates it would prove. And, Your Honor, we think that to keep him in jail without a further reduction of bond would, I don't think the term unfair would be correct, but Your Honor, he simply cannot make a $50,000 bond, and his 38 days in jail shows that.
The fact that he cannot make a bond does not make the bond unreasonable. What the issue is the bond is set where it is, based on each of these. The court just has reviewed the facts in each of these cases, the charges in each of these cases, and these are not simple possession of controlled substance charges. The first one is a possession of controlled substance with a resisting arrest. connected to it. The next set of charges are, again, a possession of controlled substance with terroristic threatening and obstructing governmental operations connected to it. And then the final set of charges are the ones that Mr. Kincaid is alluding to. So the point is that each of the three sets of charges involves some aspect of violent behavior on this individual's part. And that's why the court finds the $50,000 bond is reasonable. It's not going to reduce it any further. That'll be the ruling of the court. We're on track to move forward to trial on each of these cases. Defendant may be excused.